Please let me now invite Samoan Supreme Court Justice, Her Honour Te Whaimā Law Leilani Tuala-Warren, to share her presentation with us. Your Honour, you have the platform.
Thank you. Madam Attorney, thank you very much for that introduction. And talo palava, everyone, and thank you for the invitation. I do feel very honored to be able to share some of my experience from the bench in terms of special measures for vulnerable witnesses. All the special measures actually that I've seen in the model provisions have been encoded into Samoa's Evidence Act in 2015. Now, perhaps Madam Attorney may correct me, but our legislation does not define vulnerable witnesses. So judges have the discretion to consider things like age and maturity of a witness, their physical, intellectual, psychological, or psychiatric impairment, any trauma, their fear of intimidation, their linguistic, cultural, or religious background, nature of the evidence they're expected to give, and their relationship to any other party in the proceeding. So these are some of the things we take into account when we are considering whether somebody needs a protection that can be offered by not only the special measures that are encoded, but judges' directions. Now, once we consider those factors, this will determine the special measures to be put into place to minimize stress on the witness and to promote the recovery of a complainant. And that's all whilst ensuring a fair trial for the defendant. Now, the special measure that I have used the most is the alternative way of giving evidence. There is the use of video link evidence, and there's a special room in the Ministry of Justice from which witnesses can give their evidence. There was a lapse in the maintenance of this room for a few years by the ministry, but I understand that as we speak now, they're giving priority to getting this room operational again. Now, whilst that was happening and that wasn't, we were not able to use that, we used an empty courtroom wherever we could find one. Now, most often the use of a screen blocking off the defendant, especially in sexual cases, is commonplace. I have had sexual offending cases with complainants as young as 4 years old, and even without a prosecution application for directions as to the alternative ways of giving evidence, all judges will make directions when witnesses of sexual offences give evidence, regardless of age. Often the adult female witness also requires a safe space within which to give her evidence. We have often prohibited publication of witnesses' names and any details which may identify him or her. Only once have I disallowed a self-represented defendant from cross-examining a complainant, and this is because defendants in the Supreme Court are charged with very serious offences, so they are often granted legal aid. So they have counsel to represent them. Often I've disallowed unacceptable questions from counsel, and perhaps 3 or 4 times I have disallowed evidence of sexual reputation and sexual experience. Overall in Samoa, the lawyers are respectful and sensitive in how they ask their questions to vulnerable witnesses, especially in terms of tone. As we know, lawyers can have very intimidating, loud tones when they speak in court. But I have noticed that I've been very impressed that when it comes to them questioning, especially child complainants, all have really been considerate and respectful in that way. Now, in most assessor trials of sexual offences, I have given directions to assessors about the manner in which evidence has been given. And where there is a delay in laying a complaint, I have directed them that there may be good reasons why the victim of a sexual offence may not make or may hesitate or delay in making a complaint. We also have a provision which allows for support persons for witnesses in criminal proceedings. And this is where, for us, Samoa Victim Support Group comes in. Often on our own initiative, that's the judges, we contact Samoa Victim Support Group to be present in court to support a complainant where they have no one present and where the person has not gone to Samoa Victim Support Group. But most complainants we have noticed in sexual offending cases are brought by Samoa Victim Support Group because they are often the first port of call before they then go to the police. So Samoa Victim Support will take the complainants over to the police station to lay a complaint. So this brings me then to Samoa Victim Support Group. It's an NGO which is instrumental in Samoa in supporting and informing the court about our vulnerable witnesses. We have a wonderful woman at the helm, Lena Chang, who helped us also to establish the Family Violence Court in 2013. Now, I don't think I would have been able to do it without her, but we are very pleased that as an NGO, I think this year's government budget was the first time that they have gotten some funds from government. So outside of court, we have Samoa Victim Support Group because there's no equivalent in our government, and we rely on them to take over once our vulnerable witnesses leave the courtroom. They have a shelter, they have a school for child victims, and a shelter for victims of family violence. Now, inside the courtroom, what do we expect from prosecutors? Now, we need them to alert the court to any special measures required before a case is heard so that we are prepared. And during the hearing, as matters arise, which require us to give directions. Now, this is mostly done really well in Samoa, but I often feel there should be special training for prosecutors and judges in this area, just as there should be special training for first responders in sexual offending and family violence cases, because the court completes the cycle of engagement for vulnerable witnesses with the justice system. And therefore, this is a final and a critical step for them. So there should be training for us as well. Thank you to Nick, who sent some questions to get me thinking about my presentation. And one of them was the impact of COVID-19 on the use of special measures. Now, because Samoa went into total lockdown, the courts couldn't operate because we were caught off guard. Slowly, though, we started to use video link more often, but that was only in relation to those who were in custody. So I can honestly say we are racing to catch up right now, so that if something like this happens again, we will still be able to conduct our cases. So because the courts came to a halt, the cases within which special measures would be utilized did not proceed. Now, the result is this year, we are trying to clear sexual offending cases from 3 years ago. And the difficulty is for the vulnerable witness is that a lot of time has passed and there's a risk that the quality of their testimony is then compromised. So now more than ever, we have noticed that the environment within which they give their evidence today is really important. Now, just specifically dealing with children who are vulnerable witnesses, we have our family court rules, which are quite extensive. I'll give you just a few examples of what we have in there. We have Rule 19, which deals with views of a child or a young person, and that's when the court can exclude lawyers from the hearing so that the judge can ascertain the view of the child or the young person. We also have Rule 27, which deals with the appointment of a representative for minor or incapacitated persons. We have Rule 87, which provides for telephone conference link-ups and video conference link-ups. We have the Family Safety Act, and that's designed specifically to deal with protection orders for family violence, for victims of family violence. We have Section 8, which also encodes that principle where if a respondent is not represented by counsel, they cannot directly cross-examine the vulnerable witness or the complainant. They need to write their questions down. It needs to be given to the judge, and the judge will ask the questions. It also encodes, for example, the use of a screen between the defendant and the complainant when she or he is giving evidence, and video conferencing. So these are things that have been slowly put into our legislation to enable us to be able to provide other means for our vulnerable witnesses to give their evidence. Now, it also provides, interestingly, for duties of police to assist and inform complainants of their rights, which I think is really critically important for our vulnerable witnesses, and imposes on them a duty to prosecute. Now, that is a whole nother presentation altogether. Now, there is a lot I could delve into in this area of the law, but I think that's probably best left to the family court judge. Suffice to say, in the last 10 years, the significant legislation has been introduced, which takes into account vulnerable witnesses. But I don't think it should stop there. I think as judges, we are proactive, and I'm proud to say we are proactive in finding ways to ensure that vulnerable witnesses are able to give their evidence in an environment which is not always the friendliest. Now, it is work in progress. And as judges and prosecutors, we probably should never stop working towards reaching a point with every vulnerable witness where they are comfortable to tell their story in an unintimidating environment. Because after all, that is why we do the jobs we do, to ensure that justice is done. That was it for my presentation. I was about to say, in conclusion, I thank you all for taking time out of your busy schedules to hear me share a little bit about what we do in Samoa. I hope it's been helpful in some small way, and I will take questions. I still have a bit of time, but in case I don't have the chance to say it, enjoy the rest of the webinar. Thank you to Nick and Chase and Sophie and for helping me to get to this point. I'm not the most technologically savvy person there is out there, but thank you for all your assistance over the past few weeks. I'm sorry I'm going to miss the next presentation. And I'm sure she will be amazing. But yes, I'm open to questions now. Thank you for your attention. God bless. And yes, question time if anybody has any pressing questions they want to ask.
Thank you very much, Justice Tuala-Warren, for that very interesting and such a fantastic presentation. I was particularly interested to hear from the judiciary's perspective that the lawyers in Samoa are generally respectful, sensitive, and considerate when it comes to cross-examining especially the child victim witnesses. So thank you for sharing that with us. It's also great to hear that there's been a lot of progress in the last 10 years in terms of legislation. And thank you for the encouragement that we shouldn't rest here. There's still a lot more work to be done. So on that note, I'll open it up to the floor. If there are any questions, if anyone in the audience would like to share any particular advice from Justice Tuala-Warren you found helpful, or any particular questions you want to put to Her Honour while we have time.
Hope I haven't intimidated everybody into not asking questions.
It's because it was so clear, Your Honour.
Sorry about that, Echo. I have a question to get us started. Thank you so much for your presentation, Justice Tuala-Warren. I know you said it's a completely different whole nother presentation, but I was wondering if you could talk briefly about the impact that you've seen on police having the duty to prosecute, what changes you've seen since that duty has been introduced.
Okay, that duty was introduced in 2013, and I think since then since then, the number of cases of family violence that we have seen come through the court has increased tremendously, to the point where we created a whole family violence court to deal with family violence. Because I think in the past, there was a lot of reconciliation that was conducted by the police themselves, which we did not think was their place to get involved in. We didn't think it was their role to play, because we needed people who had committed family violence offending to actually go through the system and try some rehabilitation. That's why the family violence, it is a unique therapeutic court. So we wanted to address the causes of the offending, have a holistic approach in terms of addressing the whole family so that they come out at the end of the engagement of the criminal justice system and there are changes made. So we didn't think the reconciliation done by the police was proper, because we then saw reoffending. But yeah, it's increased significantly the number of cases that have come through.
Thank you for that. And when you say you take a whole family kind of therapeutic model, what does that mean? What kind of measures are taken?
So for the family violence court, what we had was a rehabilitation program for the offender, which often included the spouse as well. And they would go through a whole process where, if provided that she was comfortable with that, there was nothing that was imposed on the families. It was only if the spouse had a desire to go through the program with the offender. So she would be there in support. Often it was a she. She would be there to support the offender. And that would take about anywhere from 8 to 12 weeks. And at the end of that program, it was called the Men's Advocacy Group, which was done through Samoa Victim Support as well. At the end of the program, there was a graduation ceremony where you have completed the program and now you are being acknowledged for it. And that just had a huge impact on the families, because I think the spouse, the children, they're all extremely proud in seeing these changes in their father often. And that's the process that we wanted all the offenders to go through, provided it was appropriate. So the family violence court's jurisdiction was the current district court jurisdiction, which is all the offences 7 years and under. I understand that jurisdiction has been raised now, but it was 7 years and under. So we were dealing with the assault cases, the insulting words, the threatening words, any serious family violence offending would go to the Supreme Court, and that sort of therapeutic approach is not available here. So that's why that family violence court was important, and it's still going strong today with a different judge. Yeah.
Such an interesting model to hear about. Thank you. When you say provided that was appropriate, is that, as you say, based on the length of, whether up to the 7 years? Yes.
And where the spouse is willing to engage in the process. If it was, if she did not want to get involved in the process and she was leaving him, that's fine too. We concentrate on the offender, but we would never force her to be involved in a situation where she did not want to be involved any longer. So it was always a matter of appropriateness for the complainant.
Thank you very much. Are there any other questions from the audience?
Yes, can you hear me?
It's 5 minutes, so we'll make use of that opportunity for a final question.
Kia ora, Leilani, excellent presentation. Thank you very much. Here from the Cook Islands. Kia ora, everyone.
Yeah.
Just a question regarding the rehabilitation. What success rate have you had during the rehabilitation?
Well, during the time when I was in the family violence court, which was from 2013 to 2016, beginning of 2016, our recidivist rate was less than 1%, which was quite an achievement. I'm not sure what it is now. I've been told by the current family violence court judge that it still is very low. But when we first started out, it was less than 1%, which was amazing considering the recidivist rate in Samoa.
Okay, it looks like everyone is well
I've
informed by that
everybody.
clear presentation. Thank you very much, Your Honor. I think it's I think we've now come to the time where we can say thank you very much for making yourself available. Thank you for the presentation. Thank you for your patience in answering the questions. And we can now say farewell. And we want to make sure we get that in before your registrar comes in that back door again. Thank you very much, Justice Tuala-Warren.
Oh, thank you, everybody, and enjoy the rest of the webinar and have a safe weekend. Thank you for having me so far.
Thank
Thank you, Madam.